to meet their burden challenging the existence of this agreement. The agreement exists. The enforceability of it is a very different question, and that's for the arbitrator to decide. And there's been no waiver of the right to arbitrate. So the case that was previously filed here in the circuit court that Ms. Herman filed against the trustee of the trust that has an ownership interest in Mr. Wood's residence, we have fought tooth and nail to get that to arbitration. We filed a motion, the defendant in that case filed a motion to compel arbitration seeking to enforce this arbitration agreement in that case. Mr. Woods himself has filed an arbitration proceeding before the AAA. And here we have filed a motion to compel arbitration.
Is that why you asked to take judicial notice
of certain filings and the other proceeding?
That and possibly to rebut any other arguments that may be coming up.
Waiver.
I understand your argument in regards to validity. I want to move forward though. Hypothetically, if the court finds that the agreement is valid on its face, then where are you with the required steps for analysis?
I think what we're requesting, Your Honor, is to determine the scope of it.
Okay.
What is arbitrable and what is not.
Right.
Again, I know you disagree with valid on its face, but when I look at the plain language of the agreement, it seems as if the arbitration clause is very broad, and it would require that the court send the issues of validity as well as scope to an arbitrator.
There are issues that we have not filed with the court yet, facts that involve the sexual harassment problem under the EFAA. Unfortunately, because of this document, we've just been very careful on what allegations we make to the court that we put in writing, because given the broad scope, at least on its face, of the purported agreement, we don't want to run afoul of any of those provisions.
I think that there were two
There is
federal
reference to
statutes.
it, but I don't have anything beyond what I've referenced in the brief.
Okay.
And I will be issuing my order from Chambers. And just to be clear, Mr. Hodis, I guess your request is, Judge, there seems to be issues of fact, and therefore we should have an evidentiary hearing on the issue of authenticity. I'm hearing, and then on the other side, they're saying absolutely not. You have sufficient evidence in the record of authenticity. This is the agreement. It's valid on its face. The arbitration clause is broad. The attack is on the validity of the agreement overall itself and is an arbitrable issue and should be sent to the arbitrator.